Okay, picture this. It's 2 a.m. You're completely alone. You open ChatGPT and start typing thoughts you'd never say out loud to anyone. You type stuff about your job, your fears, your weird half-baked ideas. You feel safe, private, like it's just you and the machine. But what if I told you that conversation, even the one you thought was completely private, could actually land on the federal agent's desk? Because in October 2025, the United States government did exactly that. They subpoenaed OpenAI and demanded a specific user's ChatGPT conversation history. This is the story of the first known federal warrant for ChatGPT data, and what it means for every single one of us. Let's go back to 2019. Somewhere on the dark web, a network of child exploitation sites was quietly operating. Hidden, encrypted, untouchable. We're talking about 15 different dark websites, a combined user base of at least 300,000 people, all running on the anonymous Tor network. For 6 years, Homeland Security investigations, the unit inside ICE focused on cybercrime and child exploitation, was trying to unmask the admin. These sites were organized. Badges, commendations, ranks for contributors, even a dedicated category for AI-generated content. This wasn't some amateur operation. 6 years of chasing shadows. Then an undercover agent got a break, a chance to talk directly with the suspected administrator. Think about that for a second. 6 years hunting someone invisible. How would you even begin to crack that kind of case? During those undercover chats, the suspect casually mentioned something. He used ChatGPT. A lot. He even shared specific prompts and partial responses. What did those prompts look like? Not what you'd expect. One started with, "What would happen if Sherlock Holmes met Q from Star Trek?" Another was a 200,000-word poem request. ChatGPT wrote a humorous Trump-style poem about YMCA. The suspect copied and pasted the whole thing. Completely innocent prompts. Nothing criminal about Sherlock Holmes. But those specific, unique prompts became the government's fingerprint to find him. With these two prompts in hand, agents filed a federal search warrant targeting OpenAI directly. Give us everything on whoever typed these messages. The warrant demanded full conversation history, names and addresses linked to those accounts, plus payment data, credit cards, billing info, all of it. OpenAI complied. They handed over one Excel spreadsheet of data. That's it. One spreadsheet. We don't even know exactly what was in it. The suspect, 36-year-old Drew Honer, allegedly connected to the U.S. military, was charged with conspiracy to advertise child sexual abuse material. Here's the key detail, though. The government didn't actually need the OpenAI data to make the arrest. They got there through other evidence first. This wasn't random. When the government sent that warrant to OpenAI, they were using a very real, very established legal framework called the Stored Communications Act. Under this law, 18 U.S.C. Section 2703, tech companies like OpenAI are treated as electronic communication service providers. Just like your email company, the law creates two tiers. Non-content data, your name, email, payment info, can be accessed with just a subpoena. Easy, low bar. But content data, the actual words you typed, your prompts, ChatGPT's responses, that requires a full search warrant. Higher bar, but still reachable. So let me ask you something. Did you even know your ChatGPT conversations could be handed to the government? Be honest. OpenAI even has an official government user data request policy, updated January 2026. It tells law enforcement exactly how to submit requests through a portal called Codex. Before complying, OpenAI says it will notify the user, unless prohibited by law. The catch? Gag orders can delay that notification indefinitely. There are also preservation requests. Under 18 U.S.C. 2703F, OpenAI can be ordered to freeze your data for 90 days, extended another 90 if needed. In the DHS case, agents sent a preservation request on May 20th, 2025, before the warrant was even approved. Freeze first, ask questions later. Now look at the numbers. In the second half of 2024, OpenAI received 71 government data requests. By the first half of 2025, that jumped to 146. Content requests, meaning actual conversation text, went from 13 in late 2024 to 26 in early 2025, then tripled to 75 in the second half of 2025. And those national security requests, filed under FISA and NSLs, are reported separately in a vague range of 0 to 249. Every reporting period, we don't know the real number. The law only requires a vague range. That's not transparency. That's a window with the blinds half drawn. Okay, at this point you might think, yeah, but this is just like any other tech company handing over data, right? Wrong. It's fundamentally different. When you post on Instagram or tweet something, you're making a public statement. You know someone might see it. That's the deal you signed. But ChatGPT? People use it as a diary, a therapist, a brainstorming partner, a place to work through ideas they'd never say out loud. Honestly, what's the most personal thing you've ever typed into an AI? Could you imagine that showing up in a court document? Social media is your public face. AI is your internal monologue. The difference between what you tweet and what you type to ChatGPT is enormous. Think about it this way. People ask ChatGPT things they'd be embarrassed to Google. Questions about health, finances, relationships, politics, raw and unfiltered. Those conversations reveal not just what you did, but what you were thinking of doing, what you feared, what you were curious about. That's new territory. The 20th century surveillance state tracked your actions. The AI-era surveillance state could potentially map your thoughts before you act. There's actually a real court case about this right now. In U.S. versus Hepner, a defendant used Claude, Anthropic's AI, to help prepare his legal defense. The FBI seized those AI conversations as evidence. The court ruled they were not protected by attorney-client privilege. Because Claude isn't a lawyer, that ruling essentially said, whatever you type into AI has no legal shield. It's just data sitting in a server, waiting to be subpoenaed. And here's something most people miss entirely. OpenAI's policy says warrant responses can include text or files input or output in connection with use of OpenAI services. That means both sides of the conversation. Your prompts and ChatGPT's responses, the whole dialogue, your questions and the answers you received. Everything. Now, let's talk about something that rarely makes the headlines. In 2025, a court in the NYT copyright lawsuit ordered OpenAI to stop deleting user conversations indefinitely. OpenAI normally deletes your conversations within 30 days. But under this court order from April to September 2025, they had to keep everything, even deleted chats. You deleted your chat history thinking it was gone? During that period, it wasn't. It was sitting in a secured server. How does that make you feel? OpenAI fought the order, calling it an overreach. They said retaining deleted data fundamentally conflicts with the privacy commitments we made to our users. But the court said no. It denied OpenAI's motion to reconsider. The message was clear. Preserving potential evidence matters more right now than your privacy settings. Think about what that means for businesses too. If your company uses ChatGPT for strategy docs, client info, or trade secrets, that data was frozen too. Now add another layer. In 2025, the FTC issued orders to 7 major AI companies, including OpenAI, demanding detailed information about how they handle user data. The FTC wanted to know about session lengths, engagement patterns, how companies monetize user conversations, and how they protect minors using these platforms. That's the government mapping the entire anatomy of AI conversations. Duration, frequency, topics, sharing practices, behavioral metadata at industrial scale. It's not that the government is reading your chat right now. It's that the infrastructure for doing so, legally and technically, is being built in real time. Google went through this exact same evolution. Keyword warrants, location data requests. It got so bad that Google eventually stopped storing users' location history altogether. That's the trajectory. Google started as a search engine. ChatGPT starts as a helpful assistant. Both became among the richest surveillance data troves imaginable. Stanford's Center for Internet and Society raised a disturbing question after this case. What if warrants stop targeting one user and start targeting a type of thought? Google keyword warrants asked, who searched for this address? A reverse prompt warrant could ask, who typed this kind of question into ChatGPT? Imagine a warrant for everyone who asked ChatGPT about acquiring certain chemicals, or everyone who discussed border crossing, or everyone who asked about protest tactics. Think that's too extreme? Think again. Former federal magistrate Judge Brian Owsley literally wrote a law review article warning this is coming. What do you think? The current DHS warrant was properly scoped. One specific user, very clear probable cause, a horrific crime. That's how it's supposed to work legally. But not every judge reviews these warrant applications carefully. Plenty of judges approved overbroad Google keyword warrants that were later challenged as unconstitutional. And here's the thing about legal precedent. The DHS case involved child exploitation, the most sympathetic possible justification. Nobody argues for child abusers, but the exception carved out for the most extreme crime becomes the template for the next request, and the one after that, and the one after that. The pattern is well documented in modern surveillance history. Terrorism, organized crime, drug trafficking, then immigration, then political dissent. The scope always expands. Now think about what's happening in today's political climate. Governments cracking down on protesters, scrutinizing immigration, defining political speech as extremism. Stanford's Rihanna Pfefferkorn, one of the country's top digital rights experts, put it bluntly. This warrant may be the first, but it won't be the last. And there's something even more insidious than being surveilled. It's knowing you might be surveilled. Because that's when people start changing their behavior. Self-censorship. The chilling effect. People stop asking AI about mental health, about politics, about legal questions, about anything that might look suspicious out of context. Here's a real question for you. If you knew the government could read your ChatGPT conversations, would you change how you use it? Comment below. And if millions change how they use AI out of fear, we lose more than privacy. We lose the mental space to think freely and question things. Big Brother in 1984 didn't just watch people. He made sure people knew they were being watched. The watching itself was the point. The fear did the rest. Orwell imagined a telescreen on your wall. What he didn't imagine was that we'd invite the surveillance in voluntarily and call it a helpful assistant. So what can you actually do? First, yet understand that AI companies are data companies. Every conversation is a record. Every record can potentially be subpoenaed. Most AI platforms have options to disable chat history. Some offer temporary chats that aren't saved. Enterprise and zero data retention plans exist for businesses needing protection. The EFF's Jennifer Lynch said it best. It's more important than ever for OpenAI and other AI companies to think about limiting the data they collect, but individual settings only go so far. The deeper question is whether we, as a society, want to give AI companies and governments this level of access. In the social media era, we worried about what we posted publicly. In the AI era, we might need to worry about what we whisper to a machine. So here's the question I want you to sit with tonight. Did we gain a useful assistant? Or did we build the most intimate surveillance device ever created? Big Brother doesn't always arrive as a screen on the wall. Sometimes he arrives as the most patient, helpful, non-judgmental listener you've ever had. And the most terrifying part? We'll keep using it anyway. Because it's too useful. Because it's too convenient. Because we're already too dependent on it. So go ahead and ask yourself, what did you type to an AI this week? And what would you think if you knew someone else could read it? That's a wrap for today. This was the story of the first known federal warrant for ChatGPT data. And the question none of us can afford to ignore.